Historic Supreme Court arguments weekday in LGBT geographic point rights dispute. The Supreme Court grappled occasionally on weekday with historic cases that might impact immeasurable LGBTQ Americans. At the tip of 2 hours of spirited arguments, it appeared clear that the four liberals on the bench believed that federal employment law that bars discrimination-supported sex includes claims of sexual orientation and personal identity. Two separate cases were argued on weekday. One regarding whether or not the law encompasses claims of sexual orientation brought by Gerald Bostock, and therefore the estate of Donald Zarda. The opposite involved a transgender girl, Aimee Stephens, marking the primary time the court detected arguments relating to the civil rights of a transgender individual. How the justices' rule may have essential implications for the LGBTQ community created from close to 1 million employees World Health Organization establish as transgender and 7.1 million lesbian, gay and bisexual employees, in keeping with UCLA's Williams Institute. While the four liberals could aspect with the LGBTQ petitioners, it's unclear if one amongst the 5 conservative justices can be a part of them. All eyes were on conservative Justice Neil Gorsuch. World Health Organization typically focuses on the plain text of a law once analyzing it. Gorsuch told a professional for the LGBTQ aspect at one purpose, "Assume for an instant I am with you on the matter, proof, it's close, okay," suggesting he thought they might win on the plain text of the law. The question surrounds the which means of because of sex in Title VII of the Civil Rights Act of 1964. Then Gorsuch took a flip and questioned if, at the tip of the day, whether or not a choose ought to take into thought the large social upheaval that might be entailed in such a decision, and whether or not it'd be more acceptable a legislative instead of a judicial function. "It's an issue of judicial modesty," he said. There he gave the impression to believe the Trump administration and conservative Justice Prophet Alito. World Health Organization appeared the foremost skeptical of the LGBTQ position. Alito repeatedly ironed a professional for the LGBTQ petitioners if they were trying to vary the which means of what Congress understood sex to mean once it passed the law 55 years past. Alito noted that Congress had been asked repeatedly to handle the difficulty and didn't act. He questioned whether or not the court ought to get entangled during a matter of policy, higher suited to Congress. Near the tip of the spirited session, Justice Sonia Sotomayor asked peace officer Noel Francisco, "At what purpose will a court still allow unfavorable discrimination?" She asked and sighed, "We cannot deny that homosexuals square measure being unemployed just for being World Health Organization they square measure, which they are still being crushed, they're still being ostracized." Francisco, representing the Trump administration, responded curtly, "I guess my answer, Your Honor, would be at the purpose once Congress really addresses the difficulty." Justice Brett Kavanaugh failed to raise several queries and Justice Carriage Thomas was, as usual, silent. Justice John Roberts unbroken, pushing lawyers on either side of the reach of a possible opinion and the way it'd impact different cases coming back down the pike regarding problems with faith and therefore the use of public college loos by transgender students. 22 states, and the District of Columbia have statutes protective employees-supported sexual orientation, in keeping with the Williams Institute. 21 states and D.C. have statutes protective employees from discrimination-supported personal identity. In 2013, Stephens told her coworkers that she had determined to possess sex-duty assignment surgery and come back to figure as a transgender girl. "I have famous several of you for a few time currently," Stephens explained during a letter, and so she told them she had determined to possess sex-duty assignment surgery and reject the sex she'd been allotted at birth. "The opening I need to take is to measure and work regular as a lady," Stephens wrote. "I can come back to figure as my true self," she sighed, in acceptable business apparel. Not long when, she was unemployed from her job because the director of a dead room. She sued. "We have a similar basic human rights that everybody else will," Stephens aforementioned throughout a recent event in Washington hosted by her legal team at the Yank Civil Liberties Union. The case comes within the wake of the Supreme Court's call in 2015 clearing the means for twosome nationwide. However, there's a essential distinction. That opinion, Obergefell v. Hodges, was determined once Justice Anthony Kennedy, seen as a champion for LGBTQ rights, was still on the bench. He has since been replaced by Kavanaugh, thought of to possess a additional conservative outlook. The court's ultimate call, on a difficulty that's a reference point for every party's base, can come back down within the heat of the presidential election. Supporters of LGBTQ rights say there's heaps on the road. It would be immense for the LGBT community to possess protections within the personal sector from employment discrimination. That is just about a rampant drawback to the present day. Aforementioned Paul Smith, a professor at Georgetown University Law Center, World Health Organization, argued and won a landmark gay rights case in 2003. He notes that federal employment protections are a goal for many years, which a win for the LGBTQ community may inspire changes in different areas of the law as well as claims of housing discrimination.